Hi everyone, I'm JD Hoovener, your host of The Bold Today Show, where you, the inventor, entrepreneur, or business owner, get your daily dose of inspiration to make the world a better place. All right, we're in this week talking about software and software patents, how that fits into your business and how you start to think about how it really pervades all of our everyday activity. So today I want to talk about a specific case, actually two cases that really lay out the beginning of what really became sort of an onslaught of deaths for software patents. It began in 2012 with a case we're going to show up here called Mayo. In this case, there's a much longer case description, as you'll see. I call it Mayo because it started this test and to see whether a process or a machine, as we've talked about it as we talked about yesterday in the software patent, whether that fits into the category of an abstract idea. Okay, an abstract idea or a law of nature have always been ineligible, right? A law of nature like gravity or E equals mc squared, right? Our old buddy Einstein. These are ideas that are just not eligible because they belong to nature. They belong to everyone. They're part of the public domain and knowledge. Just because you found out the equation, yeah, you're a smart guy, don't get me wrong, but you don't own that. You're not going to be able to make a claim on that. So in order to get eligible patent, you've got to be able to show that you're outside of that. You're doing something more than an abstract, a natural phenomenon. And so what Mayo did is it provided a two-part test where you first analyze whether it's an abstract idea. Then you say, okay, well, even if it may be abstract, have they added something that's transformative? Have they made it substantially greater, right? Substantially more than, or improve something to the level that you can actually touch it and feel it, or put your arms around it, as it were. That's the test, and it was backed up and supported by a really landmark case called CLS Bank versus Alice. And so that case, that really set the precedent, where it said, okay, look, this case we called Mayo. We decided 2 years ago. The case of Alice was decided in 2014. Said we were right. Said we're gonna use this Mayo test and we're gonna put this two-part test in place, where we say, okay, first step is this directed to an abstract idea, and secondly, if it is, and before we kick it out and say it's ineligible, we say, is this in some way transforming the nature of it so that it's a patent eligible invention? Even if the premise, or it's directed to an abstract idea, is what's being claimed doing something else with it? Is it taking it to the next level? Is it bringing it into 3 dimensions? Is it changing temperature? Is it moving an electron around? Is it doing something with pressure or other bodies or a device, something moving that we can touch and see and feel? And as long as that's novel, non-obvious, and has utility, it is patentable. All right, well, those two landmark cases, Mayo and Alice, really set the framework for the next couple of days. We're going to be talking about these bigger cases that have come up recently. But the bottom line is that this is a huge ruling, and that many, many patents had been issued leading up until this case. And after that, there was about thousands of patents that were invalidated. Those that have already been told, hey, here's your patent, congratulations. After that case got ruled in Alice in 2014, over the next several years, even up till now, many of those patents have been ruled to be invalid under the recent law. So if you have any questions about this, I know it's a big subject. I laid a lot out there for you in about 5 minutes. Please give us a call. Go on our website and book a consultation. We'd be happy to talk with you. I'm your host, JD Hoovener of The Bold Today Show. It's been a pleasure. Go big, go bold.
Go big, go bold at boldip.com.